wonderful news. So USCIS has increased the automatic extension for some types of work permits, also known as employment authorization documents, EADS, to improve access to work permits. So remember also that last year USCIS extended the validity periods for some work permits from 2 years to 5 years. So if you have a work permit that was issued in 2024, this year it's likely going to expire in 2029 for some types of work permits. Now, a few days ago, USCIS again announced a wonderful temporary final rule that is meant to increase the automatic extension period for some employment authorization documents, or EADs. I'll explain. So when you apply for a renewal of your work permit before it expires, you are issued with a receipt notice. That receipt notice would usually extend your expiration for an additional 180 days, 6 months from the date of the expiration, meaning that it gave USCIS some time to process your new work permit. Now they are extending it to 540 days, which is about a year and 6 months, to allow them time to continue processing these work permits. So it's a temporary rule. It's not final. DHS is considering long-term solutions, and it's asking the public for comments to come up with new strategies on the issue. So if you have a work permit that expires next month and you apply for a renewal this month, you get a receipt notice after submitting your renewal work permit, and that will extend the expired green card. Okay, so the temporary measure that was announced will prevent people who have their work permits expired and are waiting for USCIS to adjudicate or to decide on their pending work permit renewal applications. It allows them to continue working, and it doesn't cause them problems, because employers will say you have an expired work permit, we're not going to allow you to continue working. So USCIS has received so many applications, a record number as they call it of applications, and so it has impacted their renewal mechanisms, and wait times have lengthened. And so again, they figured that they wanted to temporarily lengthen the existing automatic extension from 180 days to 540 days. That will avoid lapses in employment authorizations for immigrants. That's so great and thoughtful of them. So again, this temporary final rule, it will apply to two categories of EAD applicants. Number one, applicants who timely and properly file their Form I-765 applications on or after October 27, 2023. If the application is still pending on April 8th, 2024, this temporary final rule applies to them. So if your application is still pending and you filed it in October 2023, this rule applies to you. And number two, it applies to applicants who timely and properly file their Form I-765 on or after April 8th, 2024, all the way through to September 30th, 2025 next year. This rule will apply to you. 540 days of automatic extension. And a properly filed Form I-65 usually means that you filed the renewal work permit before the expiration of your current work permit. Do not wait until your work permit expires to file a renewal, okay? So now, number one, if you filed your renewal work permit on or after May 4, 2022 and before October 27, 2023, then you had a 540-day automatic extension, and so you received a notice of action, receipt notice that actually stated that you were granted a 540-day extension. Okay, now if you file a Form I-765 renewal application on or after April 8, 2024, which is just a week or two ago, then you are also going to receive the 540-day automatic extension on your notice of action. That's your receipt notice. It's known as a Form I-790 notice of action, and it explains that your expired green card, along with your receipt notice, extends your expired green card for an additional 540 days, and so you can work with the expired green card and the receipt notice. Now, if you filed a Form I-765 renewal application on or after October 27, 2023 and before April 8, 2024, and you're in these eligible categories, then you were likely issued a receipt notice of 180 days extension. So your receipt notice, the Form I-797C notice, would say you have a 180-day automatic extension. Right now, this 180-day automatic extension will, however, convert to a 540-day automatic extension. It's no longer 180 days. That receipt notice is not, it says 180 days, but it will extend for 540 days. The USCIS is not going to send you new receipt notices. They're already backlogged. They're already overwhelmed with a lot of work. So you're just going to refer to a web page that will give this information. And so if you're in this category, then you need to make sure that your employer understands that you are still eligible for the 540-day automatic extension. So they're not going to issue you with a new receipt notice or a new Form I-7C notice of action. Okay, so we're going to be looking at the categories of people or categories of immigrants whose work permits are affected by this temporary final rule. So the following categories are eligible for an automatic extension. Okay, so the eligibility category that is listed on your Form I-765 renewal application will determine your eligibility. So if you are A3 refugee, A5 asylee, you applied as under the A7 citizen of Micronesia, Marshall Islands, or Palau, this automatic extension applies to you. For A10 eligibility EAD code for withholding or of deportation or removal, it applies to you. Then A12 temporary protected status automatic extension applies to you. A17, that is the spouse of a principal E non-immigrant, this applies to you. A18 spouse of a principal L1 non-immigrant, this automatic 540-day rule applies to you. Again, remember, if you're applying for the I-765, you are supposed to mention the category under which you're applying for this work permit. Okay, so if you did put the C8, that's for people with pending asylum applications, this rule applies to you. For C9, pending adjustment of status under section 245. So for example, you're married to a US citizen and you're adjusting your status, this rule applies to you, automatic 540-day extension. Okay, and then C10, suspension of deportation applicants, those who filed before April 1st 1997, this rule applies to you. For cancellation of removal applicants and special rule cancellation of removal applicants and the NACARA, it applies to you. For C16 categories, creation of record adjustments based on continuous residence since January 1st 1972, that is those who are filing for green cards under the registry, this rule 540-day rule applies to you. C19 category, that is pending initial application for TPS, where USCIS determines applicant is prima facie eligible for TPS and can receive an EAD, this rule applies to you. 540-day automatic extension. C20 section 210 legalization pending I-700, this rule applies to you. C22 code, if you're applying for work permits under C22 code, that is section 245A legalization pending I-687, this rule applies to you. C24 code, life legalization, this rule applies to you. C26, that is H4 non-immigrants, that's the spouses of H1Bs, this rule applies to you. Then C31 VAWA self-petitioners, this is there for the abuse, so usually VAWA self-petitioners, this rule applies to you. So for the listed categories, those eligible who have had their codes mentioned, you may use your notice, the 797C receipt notice that you will have along with your expired work permit as proof of automatic extension of employment authorization for an additional 540 days after the expiration date on your work permit. You can present this to your employer and they should allow you to continue working. If you need clarification on any part of this video, you don't understand what's going on, give us a call. I know it can get a little complex. 802-780-0564 and we'll be happy to assist you. Follow me for more.